Thank you. For the record, Darryl Perry, CEO of Liberty Lobby LLC. And I have some concerns about the bill. I'm not opposed to the intent of the bill. I'm just opposed to the actual wording, specifically of lines 5 and 6, where it talks about electioneering. You may recall from previous bills that you've heard where electioneering can be construed to cover things such as wearing a t-shirt, a hat, a lapel pin, etc. So I don't think the intent here is to criminalize, say, a Canadian citizen who has a green card from wearing a t-shirt for a friend of theirs that's running for state rep or state senate. But my reading of the bill is that's exactly what would happen if lines 5 and 6 wind up being retained. Otherwise, again, I support the intent. I just think that this goes a little more broad than just prohibiting donations. And I'll answer any questions.
Question for Mr. Perry. Representative Porter, doesn't this just mimic the federal law?
I don't know if the federal law includes the words electioneering, but if it does, then I would have concerns about the federal law as well, especially, again, considering that electioneering has been construed to include things as mundane as wearing a t-shirt.
I have a question for Mr. Perry. Do you, given that you're not opposed to the purpose of this bill, do you have a suggestion on how to retain the prohibition of political expenditure by foreign national to survive and address the concern you have?
I would say strike the reference to electioneering.
That would appear in the second sentence. You could just delete the second sentence. You would suggest then just deleting it in the first sentence also.
Remove the word electioneering, for electioneering, from the first sentence and then strike the second sentence completely. That way it is clear that it is only talking about contributions, monetary contributions.
Thank you, Representative Smith.
Thank you, Madam Chair. Thank you for taking my question. My concern might be that the electioneering can cover a very wide range.
Yes.
It could be a foreign exchange student who actually is running a campaign on a campus, as compared to just another one wearing a t-shirt, or kids maybe when you're doing a visibility standing out there with a sign for a few minutes. There can be a huge range in that. I know I would have concerns about someone, a foreign person coming in and actually running a campaign or running a campaign office. That's electioneering. Where do you, that seems to me a drawing a very broad line.
I agree that electioneering is very broad, hence my concerns about the mundane being covered by the definition here. Maybe you could come up with a prohibition for volunteering for a campaign, being a paid member of a campaign staff. But again, I don't think that you should have this be so broad as to cover somebody doing something as mundane as wearing a t-shirt, a hat, lapel pin, etc.
Representative Pearson.
Thank you, Madam Chair. Thank you, Darryl, Mr. Perry, for coming tonight. So, as I understand the original bill, it's using federal definition for all of the language, really. And I just did some quick searches on electioneering and how it's defined through federal law, and then my first hit was through Citizens United, and it seems quite a bit more restrictive. And this is backed up by the FEC's own webpage that seems to define it as the same way as Citizens United defines it. It seems to be quite a bit more restrictive than how we've been ruminating. And I'll quote: any broadcast, cable, or satellite communication that refers to a clearly identified candidate for federal office, I'll give you that, that is made within 30 days of a primary or 60 days of the general election. So I guess the only difference here we would be dropping for federal office if we were including our federal definition for our state law, but it seems a lot more restrictive than t-shirts.
Right, well, the New Hampshire statute.
Do you understand the question, Mr. Perry?
Yes.
Okay. Could you tell me what it is?
Are we defining it more restrictive than that?
Right, he's asking about the difference between the definitions of electioneering at the state level and the definition at the federal level as interpreted by the U.S. Supreme Court. And there are other statutes, I don't have them in front of me, where electioneering in New Hampshire statute is interpreted to mean wearing T-shirts, lapel pins, etc., for the purposes of influencing an election. So I do think that the New Hampshire statute on electioneering is a lot more broad than the federal as interpreted through Citizens United.
Thank you. Further questions? Seeing none, thank you, Mr.